Well, good evening. My name is Mark Lazarowicz and I am the chair of the European Movement in Scotland. Tonight is the latest in our series of webinars looking at key issues and questions for the future of Europe. Many, of course, have had a focus on issues with a specific Scottish dimension, but we in Scotland, although outside of the EU, at least for the moment, know that many of the challenges we face go beyond Scotland and the UK, but face the wider UK and not just the EU itself. One of those issues is the challenge or threat, depending on your perspective, to the rule of law in Europe, and that is the subject of our webinar tonight, and I welcome all of you who are joining us tonight. We've got three excellent speakers, and I'll say you a few words about each at the beginning, although it would take most of our time tonight to do every speaker justice to their achievements and their standing. Speaking first with perspective focus on Scotland and the UK is Joanna Cherry. Joanna has been the Scottish National MP for Party MP for Edinburgh South West in the UK Parliament since 2015. She has held prominent roles in the SNP in Westminster, including as her party's Shadow Secretary for Justice and for Home Affairs. And as well as being an MP, she is, of course, an eminent lawyer, a QC, with much experience in human rights law and human rights cases. Our next speaker will be Marcin, who is the Professor of Social Sciences within Legal Science in the Faculty of Law and Administration at the University of Warsaw. His specialisms include public law and the judicial application of law. He is also a partner in the law firm of Domański Zakrzewski Pelinka, where he specializes in pharmaceutical and food law. He is also a regular commentator in the media on legal and constitutional issues in Poland, and he will, of course, focus on the position in Poland. And our final speaker will be Ian Forrester, who I think can be fairly said to be one of the most prominent and eminent lawyers from the Scottish legal tradition. He was admitted to the Faculty of Advocates in 1972, and since then has also become a member of a bar in England, New York, and Brussels. He is a well-known practitioner in many fields of European law, leading to his appointment by the UK in 2015 to be the judge from the UK on the General Court of the European Union, where he was the last UK judge. Obviously, with his wide experience of law, not just in the courts of the EU, but many other forums besides, is in an ideal position to look at the issue from a wide European perspective. Welcome to you all, and I'd like to ask Joanna to speak to us this evening.
Thank you very much, Mark. It's a real pleasure to join EMIS this evening and to be part of such a fantastic panel. As you said, I'm going to talk about the current situation in the United Kingdom and Scotland, and clearly, you know, I'm in Parliament just now. We're in the midst of a crisis here about whether or not the British government considers itself, or members of the British government consider themselves to be above the laws that they make for the rest of us to obey. And there really couldn't be a sharper example of a rule of law issue than that. But if we think back before COVID times, not long after the current Prime Minister came into office, in September 2019, he and his government suffered a very significant defeat in the Supreme Courts of the United Kingdom and Scotland when his prorogation of Parliament was ruled unlawful. And I was very proud to play a role in the Scottish case, but I couldn't have done it alone. I couldn't have done it without the assistance of Jolyon Mon, and indeed all the other MPs and peers that joined in, and most importantly, members of the public, some of whom I suspect are on this call, who donated to our efforts. But I think it's very significant that despite the fact that it was in effect found that the Prime Minister had unlawfully suspended Parliament in a democracy and misled, or if you like, lied to the Queen, rather than getting a contrite response at that time, we saw a very combative one laced with denial. And I think the fallout of these cases has led to repeated attacks, not just on the legal profession and the judiciary, but the rule of law itself, when you look at proposals to restrict, for example, the right to judicial review of government action, which we've just been dealing with and voting on this afternoon. And of course, since the prorogation case, we've had the internal market bill, where the British government was proposing to renege upon the agreements it had made with the European Union. And it will be recalled that the UK government's Scottish law officer, the Advocate General, resigned over that, as did the government's Jonathan Jones, the head of the UK government's legal department at the time. And indeed at the time, every living Prime Minister and the Bar Council and the Law Society of England and Wales took the view that that bill did propose to break international obligations. They rode back from it a bit, but I think, as the former Prime Minister Theresa May has said, the damage was done both in the signal that was sent out internationally, the signal that was sent out to the European Union, with whom we were still negotiating at that time, and also the signal that was sent out in relation to the United Kingdom's intentions about keeping its legal undertakings in respect of the Good Friday Agreement, which of course is the foundation of peace in the north of Ireland. And since that internal market bill, we've had various other pieces of legislation which breach international treaties and obligations. Just take the Nationality and Borders Bill, for example. The Joint Committee of Human Rights, of which I'm the Deputy Chair, it's a cross-party committee of peers and MPs, has found that that bill breaks international refugee conventions and also undermines or breaks rights protected by the European Convention of Human Rights. We've had the police bill, which very hugely circumspects freedom of assembly in England and Wales. And of course, as I said earlier, we've had the Judicial Review Bill today, and reviews into the scope and application of the Human Rights Act are pending. So, I mean, I think it's fair to say that the rule of law is under attack in the United Kingdom, and really there can be no greater threat to the rule of law than a Prime Minister who acts as though he or she is above the law. Now, I'm talking about the rule of law, and I realise I'm speaking to an audience that will have many lawyers in it, but some people who aren't lawyers. So I thought what I would do is try and set out to define what the rule of law is. And I'm not going to seek to give my own definition. I'm going to defer to a very famous English jurist, Lord Bingham, who's widely respected north and south of the border and indeed internationally. And he set out 8 principles of the rule of law. And I'm going to go through those 8 principles and then perhaps comment on how I think certain of them are being breached by actions of the United Kingdom government. So Lord Bingham's 8 rule of law principles were as follows. First of all, the law should be accessible and predictable. Secondly, legal questions should be determined according to the law, not by the exercise of discretion. So people can arrange their lives and predict what's going to happen by being able to look at the law rather than by being ruled by somebody else's whim. The third principle is that the law should apply equally to all, except where objective differences justify differentiation. Now, if I pause there, I think we see that third principle of the rule of law, equality before the law, is very much challenged in the current crisis at Westminster, where it seems at least that there are very good grounds to believe that the Prime Minister and other members of the government and civil servants during the height of lockdown ignored the rules that were set down for the rest of us. So while my constituents were unable to visit their elderly relatives or indeed be at the bedsides of elderly relatives, never mind have social gatherings, there were regular social gatherings taking place at Number 10 and elsewhere in Whitehall. So there we have a very stark example of a challenge to the principle of equality before the law. And again, if you look at the work of the Joint Committee of Human Rights, we looked at the many, many people who received fixed penalty notices in England, but it also happened north of the border during the height of the COVID crisis, and felt that many of those had been imposed unfairly. And I think that's even more starker now when we see the attitude the Prime Minister was taking towards observance of the rules. The fourth principle of the rule of law is that ministers and public officers at all levels must exercise the powers conferred on them in good faith, fairly, and for the purpose for which those powers were conferred, without exceeding the limits of those powers or acting unreasonably. And the way in which we enforce that aspect of the rule of law is, well, one way in which we enforce it is by affording to ordinary citizens the power of judicial review, the power to seek review in the courts of administrative action. And it's that power which the government are seeking to, the UK government are seeking to circumscribe with the Judicial Review Bill that's going through Parliament this afternoon. The fifth principle that Lord Bingham identified was that the law must afford adequate protection of fundamental human rights. Of course, for a long time in the United Kingdom, what has been recognised as the ultimate statement of fundamental human rights is the European Convention on Human Rights. But there are those who are part of the current government who would like to see us withdraw from that altogether. In fairness, the current Lord Chancellor has said that he doesn't want to withdraw from the ECHR, but he wants to recalibrate the Human Rights Act and have a British Bill of Rights, which may incorporate some of the ECHR rights, but will also contain other ones. But perhaps most crucially, what's envisaged is that it may not be as easy for ordinary members of the public to challenge government action or the actions of public authorities where they say their ECHR rights have been breached. And that was the whole point of the Human Rights Act, to bring it down to earth so people could access it in the courts of the United Kingdom's domestic legal systems. The sixth principle of Lord Bingham's rule of law is that means must be provided for resolving without prohibitive cost or inordinate delay bona fide civil disputes which the parties themselves are unable to resolve. And I pause there to say that certainly I know many of my colleagues at the English bar and at the English Law Society would question whether that principle is being effectively observed because of the way in which legal aid has been so drastically cut back in south of the border. Now, I know that there's Scots lawyers on this call will be saying, Joanna, there's a legal aid crisis in Scotland, and I understand that many people have legitimate concerns about the way in which legal aid rates have not been fairly set or increased for a long time. However, the availability of legal aid to ordinary punters in Scotland is much wider than it is south of the border. The seventh principle of Lord Bingham's rule of law is that adjudicative procedures provided by the state should be fair. And then the eighth principle is that the state must comply with its obligations in international law, just as it does in national law. Well, clearly, we've seen that eighth principle very much challenged by some of the legislation that's gone through the UK Parliament, including the Internal Market Bill and the Nationality Bill, just to mention a couple. Now, another aspect of the challenge to the rule of law in the United Kingdom has been the increasingly inappropriate rhetoric of some politicians in relation to the judiciary and the legal profession. And I think, if we cast our minds back to September 2020, when the Home Secretary, Priti Patel, was making speeches about activist lawyers, and the Prime Minister was very much joining in on her side in relation to that. And if we cast our minds further back, you'll remember the enemies of the people attacks on the English judiciary during the height of the Brexit crisis and the failure of Liz Truss, who was then the Justice Secretary, to defend them adequately. And recently also, in relation to the verdict of the Bristol jury in the Colston case, we've had a number of politicians in the Conservative and Unionist Party attacking that verdict and claiming that it was somehow a challenge to the rule of law. And we've had the Attorney General, Suella Braverman, saying that she was going to refer it to the Court of Appeal. And I think what I'd like to say about that is that politicians of all parties should respect the decisions that juries make, because the jury is in the unique position of having heard all the evidence and the arguments, whereas the politicians have not. And I would apply that to politicians of all parties, north and south of the border. I think it's very unhealthy for politicians to go on the record questioning any jury verdict, whether they like it or not is really a matter they should keep to themselves. But I think it's particularly important that a law officer like the Attorney General shouldn't lightly say that she's going to refer an issue to the Court of Appeal unless she's actually identified a point of law in need of clarification. And I think the attacks in the Colson case really sit very uncomfortably coming from a government, which has a record such as the unlawful prorogation of Parliament, a record of producing a bill like the Internal Market Bill, a record of perhaps not respecting the principle of equality before the law in relation to the parties at number 10. I think it's pretty rich for lectures on the rule of law to be given by such a government. But I don't want to appear entirely partisan, and I'm not going to say that the government formed by my colleagues in Edinburgh is above reproach. We know that recently the Lord President has criticised the Scottish Government's plans to reform the regulation of the legal profession and questioned whether transferring regulatory powers from the Court of Session and its Lord President to a body responsible to MSPs, he questioned whether that would create an unwarranted and unacceptable interference by the government and Parliament with the judiciary. And I think there's a very real debate to be had there about the degree to which government or indeed Parliament should interfere in the regulation of the legal profession. Likewise, those of you who read the newspapers and who go on Twitter will know that I have questioned whether the hate crime bill that was passed through Holyrood last year properly protects the right of freedom of belief and conscience under Article 9 of the ECHR and the right of freedom of speech under Article 10. I remain of the view that that bill should have had defences to some of the proper full defences to some of the stirring up crimes in it. And I'm very much fortified by the view that the English Law Society has taken recently in relation to hate crime. They're all for hate crime legislation south of the border, but they say there must be proper defences to protect people's Article 9 and Article 10 rights. And of course, if it turns out that the hate crime bill, when it's brought into force, doesn't properly adequately defend Article 9 and Article 10 rights, then there could well be a legal challenge to it. Finally, I just want to say something very briefly before my time's up about how the rule of law should really also encompass protecting the Constitution, and how I feel that the Constitution of the United Kingdom is under attack by the Judicial Review Bill that went through this afternoon, because aspects of it interfere with the jurisdiction of the Court of Session. That has been admitted by one of the ministers in a letter to me. And of course, the supervisory jurisdiction, the jurisdiction of the Court of Session, is protected by Article 19 of the Treaty of Union between Scotland and England, and also judicial review is a devolved matter for the Scottish Parliament. So the UK Parliament really shouldn't be legislating in relation to these matters, but attempts to amend the bill to stop them from doing that this afternoon have failed, notwithstanding the fact that they haven't sought a legislative consent motion. And I see I'm just a wee bit over time, Mark, so I'll leave it there. Thank you.
Well, thank you very much indeed, Joanna. The way we're going to run the questions and answer this evening is we're going to hear our three speakers first, and then we will have a Q&A to the panel as a whole. If you have questions, please put them in the Q&A box, not the chat, the Q&A function, and I will moderate the questions later on, and we'll try and get to as many as possible. But I'd like to go straight over now to Marcin. Thank you for coming, joining us tonight.
Thank you very much, and thank you for inviting me. It's a pleasure to be here. My plan for today is to tell you something about what happened in Poland starting in 2015, because it's been 6 years when this attack at the rule of law is still witnessed by us as Polish citizens, but also to interpret the underlying causes of what happened, because this is a local issue, this is a Polish issue, but at the same time it is a European issue, and I do believe that others can learn from Poland if we really understand what happened in a democracy that used to be a blueprint of a successful transformation from the communism to freedom, and a democracy that witnessed some kind of crisis when the Law and Justice Party that is still in power started governing in 2015. So, I'm a lawyer, so it was somehow natural for me to interpret what happened in legal terms. And let me start with this level of analysis. However, my overall purpose is simply to encourage you to think about the rule of law crisis, not only in legal terms, but also in sociological terms and psychological terms, because this is what happened to me. So I somehow evolved in understanding what happened in Poland from my legal background to more sociological, psychological background, because I think it is a multi-level phenomenon. So, the crisis started in 2015. And as I said, first, it started as a Polish issue. Then EU was involved in several interventions concerning the Article 7 procedure and the particular challenges for the Polish so-called reforms of the judicial system. But let me start this legal analysis of what happened with an interesting poll I've once seen, because I think we may think that if something wrong, if something problematic happens with the rule of law, and we have the EU institutions intervening, that's always a good thing. But I've seen a poll, and let me start with it, showing that with every intervention of the EU in Poland, so Article 7 procedure and then further procedures that were started against Poland, the support rate for the Law and Justice Party, which is guilty of all this crimes against the rule of law, increased. So that's a phenomenon that I want to start with, because I believe that probably when we analyze what happened in Poland, not only at the legal level, but also at the sociological and psychological level, we can have an answer why this is the fact that we have an intervention, we have the law applied to Poland, and nevertheless, the support for the authoritarian party increases. That's a phenomenon for me, and I will come back to this at the end of my speech. So as far as the legal level is concerned, it all started with an attack at the Polish Constitutional Court, Constitutional Tribunal. As you know, we have a constitutional tribunal that is similar to the German Constitutional Court, Bundesverfassungsgericht. So the constitutional review of the legislation is the only function of this constitutional tribunal, this constitutional court. We have also a Supreme Court that was also attacked. But first was the Constitutional Court. It started with packing the court with additional judges, some of them being very close to the governing party. Later on, some of them being the former politicians of the Law and Justice Party, which allowed the Law and Justice Party to govern without any challenge from the Constitutional Court. So the numbers are quite important here. So the number of cases before the Polish Constitutional Court between 2016 and 2020 dropped by 85%. It is not because all our legislation is constitutional, but people simply do not see any sense in challenging the Polish legislation in front of the court that has been completely commandeered by the governing part. So after commandeering the Constitutional Tribunal, the Law and Justice Party attacked the National Judiciary Council, which is the constitutional body responsible for appointing judges. And they changed the procedure of appointing the members of the National Judiciary Council in order to have an influence on who becomes a judge in Poland. And they were successful. With this National Judiciary Council commandeer, they started appointing loyal judges, also at the level of the Supreme Court. Especially they created two special chambers, including the disciplinary chamber, which is in fact a special court for harassing judges and the attorneys who are not loyal to the government. At the moment, all these things, so the Constitutional Tribunal, the National Judiciary Council, and the Supreme Court, especially the disciplinary chamber, are the main points of contest and discussion between the European Union and Poland. And we do hope that at this legal level, it may be somehow solved. We will see. But I would say that the whole idea behind this all changes is simply to somehow change the Polish system from the separation of powers to the unity of power, because it is not only about dismantling the rule of law. It's not only about dismantling the checks and balances. It is about, removing all the factors that may somehow challenge the government, because the attacks I was describing were, of course, the attacks against the legal institutions, but the same applies to media. You probably heard about the attempt to change the law in order not to grant the necessary concession for the one of the most important Polish TVs owned by Discovery. It is also about somehow controlling universities as independent entities. So the legal issue, the legal idea, I think, behind this, the whole process is simply to remove all the sources from which any challenge to the governing party may come. But as I said, after many years of analyzing it, I realized that this is not only the legal level, that something happened at the sociological level as well, as far as the people's readiness to support the separation of powers, the rule of law is concerned. And I believe probably from this perspective, you may find the Polish case interesting because you can learn something from the Polish case. So I realized that it is not so easy to get the support from the people in dismantling the rule of law if the people do not feel that that's the right thing to do. And it may come to you as a surprise, but as I said, the Law and Justice Party still enjoys quite a high support from the Polish citizens. It's about 30%. So they can still win the next election. So lawyers must ask this difficult question: what is behind the legal surface? My experience was that when I try to explain to the people that it is really wrong to dismantle the rule of law, I sometimes encounter a question mark. Why is it so wrong? Why do we need it? And the social aspect, this next level of this crisis, I think was best explained by Karen Steiner, who is a political scientist and a philosopher. And she tried to diagnose the societies like the Polish society. And she proposed the following idea. People have problems with diversity nowadays. So diversity within the society at every level, at diversity of ideas, diversity of sexual orientation, diversity of opinions in the media, political diversity, is what she calls the cacophony of the current democracy. People are somehow not able to accept this diversity for some reasons, and therefore they support the government that promises to reduce the diversity. Because this is exactly what the Law and Justice Party is doing in Poland. Dismantling the checks and balances, dismantling the rule of law is to remove diversity. Because if you move from 3 branches of government to the unity of power, you lower the diversity. Yeah? If you try if you use propaganda, and propaganda is very powerful in Poland at the moment at the level of the governmental media or the media controlled by the government, and you refuse the other opinions to be broadcasted because you want to close the TV station owned by the foreign company, this is to reduce diversity. And quite surprisingly, this is something that people support. We need to think about this. Why is this so? One of the arguments is that the authoritarian government like that in Poland was quite successful in convincing people that the rule of law and the checks and balances are not the good instruments to solve their problems. Probably this puts some burden on us as people who support the rule of law to be able to explain why this is the right thing to approach social problems. So, for example, at the moment, the Polish Law and Justice, the governing party, is enjoying, as I said, a lot of support for being very dynamic and quick in the legislation process. Normally, we lawyers believe that that's not the right thing to do, that you need deliberation, that you need discussion. This is what makes law good law, when you have people in the parliament discussing and deliberating on the content of the law. This is not the case in Poland. It is possible to have a new legislation passed within several hours, and this dynamism, this kind of this quickness with the law somehow finds the support of the people. This is a question to us, and this is a challenge to us, I believe, to find out why is it so. So there is some underlying social crisis, the crisis of the liberal values, the crisis of diversity, that makes the legal level, I think, a symptom of something much deeper. And therefore, I believe we need to look at this, at the problems from a more holistic view. And finally, there is, I think, the psychological level as well. And we know that this is quite an important level. We can learn from the great thinkers like Erich Fromm or Hannah Arendt, who try to analyze the crisis, the crises of liberal values through looking into the psyche of the people. And we can see it in Poland. The technological change, the informational revolution made it more difficult for the people to understand how abstract systems work. Rule of law is an abstract system. It is quite successful at the abstract level, but can have a side effects at the individual level. You know, I work also with in the area of pharmaceutical law. So a parallel to vaccination and anti-vaccination movements is a right one, I think, here. You know, vaccination works as a system, but it has side effects at the individual level. You know, if you read the philosophers like and writers like Jacek Dukaj, a Polish writer, he believes that the changes in the technological in the technology, especially the fact that nowadays people do not perceive the world through words. They don't read, they look at photographs, at videos, make it more difficult for them to think in abstract terms. So when they have a direct access to emotions, they are more they are impacted by the propaganda, by this. But what I want to say is that if you have a society that has difficulty in understanding how the abstract system works, but is more focused on the side effects, on injustice, which sometimes is an effect of what courts do. The same process, which can be seen in the anti-vaccination movement, is in operation here. You are more interested in removing the individual injustice, individual side effects, even if it involves sacrificing the system. And that's a final issue that for me is quite important. Why is it so? There is something happening here, not only at the legal level, but also at the social level and the psychological level. And this poll I started with, in which the Polish citizens seems to support more and more the law and justice government because of the intervention of the European Union, can be surprising. But if you see it through the perspective of these three levels, the legal, sociological, and psychological, you can understand that sometimes the need to feel the unity within the country, within a society, may be more important for some people than the rule of law. And this is the challenge for us, because if we keep this discussion about the rule of law crisis at the legal level only, and we don't dig deeper into the causes that underlie the crisis, I'm not sure we are able to solve it. So therefore, I hope the Polish case, with the three levels I try to highlight, can be a lesson that we need a holistic approach. Not only lawyers, but we should invite people who understand what's going on within the society, because the legal crisis, the rule of law crisis, may be only a symptom of something much deeper. Thank you very much.
Thank you much indeed, Marcin. And we'll go straight over now to Ian Forster. Yeah. You are muted. That's you've gone mute again. That's it. That's it.
There we go. Good. I begin with a couple of personal remarks, and then I'll try to echo what has been said about the interest for the individual, and then a couple of legal points. When the Brexit debate was hot and heavy, I heard myself described, I think on the BBC, as an unelected judge, and I couldn't do other than plead guilty to that reproach. But when I was called in one paper a pompous traitor, I said that I knew about the pompous, but I thought the traitor was a bit unfair. Now, that to confirm that, or to observe that the UK has been deeply involved in questions of human rights and fundamental due process for a very long time. When I was sworn in as a judge, Michael Gove, no less, came, and nothing less than the Hereford copy of Magna Carta was delivered to the Court of Justice for a week, accompanied by someone from the cathedral. And Michael Gove made an absolutely brilliant speech, superb, to the assembled justice ministers about British leadership in the drafting of the rule of law, in the drafting of the Human Rights Convention, and he managed to link it to Magna Carta and a bit of constitutional history after the Civil War, a really stellar performance. And none of the assembled ministers of justice, I think, could have possibly matched anything of that level of brilliance. So from 1950-ish and the drafting of the convention by, I think, a Scottish lawyer, to 2015, the UK was a distinguished leader in the development of fundamental principles and a defender of those. And that's nice. Now, I think it's not going to go away. And as Joanna pointed out, the topic is going to be a hot one for at least this year and longer. Brexit is not going to make the issue disappear either. Now, we're talking about the rule of law, judicial independence, and so on. It's easy to become a bit abstract. And I want to tell you that I know a number of judges who have, not many, not personally at least, who have produced a judgment which displeased the governing party or the government, same thing. And I know one who 2 days after he delivered an unsatisfactory judgment, went to his office and discovered the nameplate had been removed, that the phone had been snipped off at the wall, that his car had been towed away, and that his secretary had been assigned to other duty, and that he would not actually lose his job, but would be assigned to a remote corner of the country in a trivial administrative role. He went to court and he lost. Now, there are quite a number of people who have suffered in individual countries in Eastern Europe in that manner. They have pensions, they have families, they have reputations, they have self-regard, they have children in schools, they need to live their lives. And being sniped at by the government and worse, is a serious threat to judicial independence. Now, I often, before I went on the bench, was invited to give lectures in Eastern Europe, mainly the Western Balkans. And I would start by talking about the individual and sort of heroic battlers for individual rights. Madame de Fresne, who took on Sabina and established indirectly equal rights with respect to pay for men and women. And that's a nice story. The Liège barmaids, the ones who were French and would be deported, and the ones who were Belgian and wouldn't be, and would be given a trivial fine. Those stories of individual rights, Bosman, although I disagreed with that judgment, that got the interest of the individuals. And then I would say, and I still believe it to be true, if you go into a rather scruffy legal practice in Inverness or Salzburg or Ravenna, you're in the presence of a practicing lawyer who has the power to overturn the ruling, the decision, the legislation, the act of the public authority. Not often, but sometimes. And everyone knows that lawyer has that power. And I would end my talk by saying, here we've got the flower of the local bar, the most distinguished professors, and you know that that would never happen in your country. If your country is to become a member state, that has got to change. And there would normally be a roar of applause from the students and from the practicing lawyers. So it's good, I believe, to draw attention to the status of individuals who fight for justice as they see it, who try to vindicate their rights. And to bear in mind the suffering, and that's not too strong, the distress, the pressure that judges have in coping with governmental hostility. Now, let me mention just briefly the convention and the charter, and they sort of coincide. And they say that they define what we're talking about as the notion as having three elements. One, that a court has to be established by law. Two, that the judges have to be, the judges have to be independent. And third, that they must be impartial. Now, that is necessary to deliver the notion of a fair trial. It's not in abstract terms difficult to understand any of those elements. But when applied by a governing party that is reluctant to see courts interfering with government policy, it becomes sharp and painful on an individual level for the litigant and an individual level for the judges. And I have known a number of national judges who suffered this way, and I have known on international courts judges who were under long-term threat of being removed or not appointed because of the displeasure of their governments. Now, that means, or I would want to say, that this is not confined to fragments of former Yugoslavia. As Joanna pointed out, it is a phenomenon that is very much alive today in the UK. And we hear the Attorney General, to name but one, complaining that the courts got it wrong, that the jury got it wrong, and therefore the law must be changed. So this notion, I'm stating the obvious, and no one is going to disagree with me, it's fundamental and it's important and it's obvious. this is an important, a crucial issue for our time. Now then, it will often happen that it is suggested that what Americans might call mission creep touches what the judges, the European judges, do. It is correct, I think, that the European Court, especially in the early days, in the 70s and 80s, took pretty consistently a pro-integration line on matters of freedom of movement of goods, for example, on technical regulations, where the court was radical in other areas where the member states had not been able to reach agreement. Now, does that mean, what is that as a problem? Is that a genuine reproach? Yes, I think it is. It's not at all unreasonable to admit that there are grounds for anxiety, it is not obvious that the pro-integration approach of the European Court has always been incapable, manifestly correct. And so criticism is perfect, and doubt is perfectly appropriate and normal. And that has existed for decades. You'll recollect, and I say to the non-lawyers, the Solange judgments. The German Constitutional Court was asked to comment on the interface and the priority, the supremacy of European law as contrasted with German constitutional law. And the German Constitutional Court was a bit hesitant, a little bit grumpy, and said, for as long as you bear our concerns in mind, okay, we're not going to be difficult. Now, that dialogue, that signaling of hesitation is from member state courts entirely appropriate. And I disagree, I regret very much that the European Court elected not to endorse the treaty by which, or the arrangements by which the European Court would be linked, as it were, to the Human Rights Court. Now, that shows to me a regrettable timidity. But the Court of Justice has, it must be said, taken a number of decisions in rule of law cases recently, which have established a good basis for addressing the problems identified by Marcin. And the case about Portuguese judges is a good example. Portuguese judges during a time of crisis were told, sorry, we all have to tighten our belts and your salary is going to go down by X%. And they challenged this as being inconsistent with judicial independence. They lost their case on that point, but the court took the opportunity to produce some powerful language relevant to the situation where the ruling party tries to capture and emasculate the powers of the judiciary. And the court said, courts should exercise their judicial functions without taking orders or instructions from any source whatever. So it's now the duty of member states to achieve a regime where judicial independence can flourish. Now, in Poland and Hungary at the moment, as we know very well, there's evident problems because of the efforts of the ruling party to remove judges from office, to punish them for unwelcome judgments, to emasculate the scope of judicial review, and to establish even new courts to thwart regularly appointed judges from doing their job. Now, addressing these cases as they present themselves offers the court, or obliges the court, to do some judicial creativity, the court in Luxembourg. Now, I repeat, the challenge in Luxembourg is technical, intellectual, tricky, delicate. But the challenge in the countries at stake is really brutal. And I have heard very painful stories, personal stories, which are deeply troublesome. So I think this debate tonight is an excellent continuation of the discussion. Thanks.
Thank you much indeed, Ian, for that contribution. And what I want to do first is lots of questions. There's one question which, Ian, I think you indicated you would like to answer live, which I think could be asked of all our three panelists. And perhaps I might go to Joanna first to allow her to address it before she has to go off to the vote and any other issues that come up, which is a question, is it simply the fact that people don't understand the complex questions of the Constitution? Shouldn't lawyers explain complexity in more simple terms? I've also got a comment later on from Silva, which making the point that the education system has never taught people to understand democracy and its values. That's a question of someone in Poland, I think, but it's maybe a question which also applies to the UK as well. So what can lawyers do to make these issues, complex issues, more simple? Can they do that? Should they do that? What about education for democracy and rule of law in schools and elsewhere? I'll take Joanna first if I can, then perhaps go to Marcin and then back to yourself, Ian. That might do it. Joanna.
Thanks, Mark. Can I just firstly apologise to everybody on the seminar that I've got to leave in 5 minutes to go get myself across the other side of the parliamentary estate to vote. But yes, I'm just trying to remember. I think it's the government's report on the Human Rights Act, or it might have been the independent review on the Human Rights Act, which recommended that we should have more education in schools on human rights and associated matters. And I think, as I understand it, certainly in schools in Scotland, some of these issues are covered in the modern studies curriculum. But yeah, I mean, I can't disagree with the question. Of course, we should. Of course, the law, one of the principles of the rule of law is that law should be accessible. And, I'm the first person to admit that myself and other lawyers do sometimes forget that we're sort of speaking our own language sometimes. And today I tried to be as clear as I could, but I apologize if I wasn't. But I do think, yes, in order for people to be able to exercise their rights and hold power to account, which is a crucial aspect of the rule of law, people have to understand what their rights are, and people have to understand how they can hold power to account. So I hope that answers your question. That's my bell. I'm going to have to go and vote. Thank you so much for having me. I'm sorry I've got to go. I'm very disappointed to miss the rest of the seminar. And thank you, Mark, and my fellow panelists, and Caitlin, and of course, David. Thank you.
Thank you, Joanna. Goodbye. And perhaps I can now go over to Marcin to address this question. Also, there's another question which links to this one. It's not just a question of educating about the law, but also educating about diversity and what can lawyers do, what can the system do as well. Marcin.
I believe that from time to time we all fell prey to a very old Socratic belief that people who do wrong do it because they don't know what's good, and if we tell them what's good, they will stop doing these bad things against the rule of law. I think it is partially true. We need education, but it must be a special education. I can share with you my attempt of education. I'm a law professor, but my son is not a lawyer. My son is a rapper. Quite a good one in Poland, and I wrote a book teaching about democracy and the rule of law through his songs. So this book consists in several chapters chapters, and each starts with one hip hop song, and then I try to tell something important about freedom, freedom of expression, diversity, the necessity to accept them. I think we need a new education. We need to talk to younger people, especially in their language. It's very difficult for lawyers with all their legalese, you know, with all these complex sentences, and especially with what I touched upon in my presentation, with understanding legal issues at the very abstract level and not trying to put them, you know, at the lower level, at the concrete level. You know, they say that, you know, the rule of law is like the laws of physics. You simply don't care about them until you hit the tree with your car. And, you know, in Poland, the attack at the abstract constitutional tribunal was, I think, not a great shock for the Polish society. A part of the society protested against this attack. These were, I mean, people of my generation and older generation who understand how the abstract mechanisms work. However, the younger people start protesting when this commandeered constitutional court changed the abortion law, because that was the moment when they hit the tree, because something that was very abstract became very concrete. You know, the law, the constitutional tribunal entered their life, yeah, in a very concrete terms, their families and their life. So we need to find a way to educate about the concrete effects of these abstract systems. And it's very difficult because lawyers, I mean, they generally think in abstract terms. So we need to find a new language. We need to find the new ways of communication. And I said that it is a Socratic conviction that when we find good arguments, we will convince the people. As I said, that's only partially true because we sometimes forget that people think not only with their intellect, but also with their emotions. And that's another issue I think it's important to discuss. The rule of law is attacked at 3 levels. And it is not only attacked at the intellectual level, but at the emotional level. You know, the citizens of Poland may support their governing party against the European Union because they believe that their identity is somehow endangered by the intervention by the EU. The government uses emotions and propaganda, the feeling of unity, the feeling of being a part of something that is bigger than individual. My question is, are we able to respond not only at the intellectual level, but also at the emotional level? For me, such an answer can be found in the United States idea of the constitutional patriotism, which is not only based on the intellectual understanding of how the rule of law works, but also some kind of emotional link to the constitution, to the rights, to the tradition. It must be somehow built with the stories about heroic judges, about you know, I don't know, about anything which connects the intellect with the emotion. So I always ask myself a question, are young people in Poland excited about, for example, becoming a judge in the future, as they sometimes are about becoming a firefighter? You know, are we able to show the role of the judge, not only in the intellectual abstract terms, but in the individual emotional terms? It is very difficult, but I hope it is possible. So we need to think about changing this communication. And I agree, if we do, and if we address both the intellectual and emotional level, we may be successful in defending the rule of law against the attacks that are both intellectual and emotional.
Thank you, Marcin. Ian.
Well, I used to say that the judgments of the court where I was, which I enjoyed enormously, I said that our judgments were too long, too wordy, too dull, too difficult to understand. That is a consequence of the organization of the court. It has 24 working languages, 1 official language, which is French, and their collective judgments. So the task of the reporting judge is to build something which his colleagues or her colleagues will broadly agree with, and then it gets translated into the national language. Now, that means that very often the judgments are wordy and they're far too long, whereas in the British tradition, England and Scotland, there's an emphasis on the facts. And I think that it's much easier to understand and sympathize with the problems of the individual, Mrs. Donoghue, who bought famously ginger beer, iced drink tainted with allegedly a decomposing snail. That's about 100 years ago. Now, the individual facts are much more thrilling, if that's the word, or intriguing, stimulating, than the abstract notion that someone who puts on the market a product which is a generic product and which causes harm to someone else, even though they have no contractual relationship, that's an abstract statement of the law, a civilian approach to the issue. So I believe that concrete examples of the victors are much more easily understood, remembered, and recounted by parents to children than abstract formulations.
Okay, thank you, Ian. I want to turn to another theme of our questions, one of which is a question from Ewan McPhee, which is the more recent one in the Q&A box. How effective will it be to link the public purse strings to adherence to the rule of law, just as the EU is now doing with a new budget conditionality mechanism? Will this approach be effective? And another question which came up earlier on in the Q&A was, is the EU as a whole using all the tools which are open to it to try and address challenges to the rule of law in member states? So, Marcin, do you want to answer that first and then perhaps go back to Ian again?
Okay, thank you. You know, I've been thinking for a long time about this conditionality mechanism because I think it may be effective because it is about drawing concrete consequences from, neglecting abstract systems, or attacking abstract systems. Because money is the most concrete thing you can imagine. And if you show that, unfortunately, if you don't have a rule of law system in place, if you don't have independent judges that can check how you spend the money, it is very important to give you the money. So it's such a simple mechanism that everyone can understand it, and it shows that that one has to pay the price, the concrete price for destroying the abstract mechanism. On the other hand, this is a very tough tool, a very tough intervention. And as I said, the previous interventions of the EU institutions encountered some kind of paradoxical reaction. So it was easy for the government of Poland to show these interventions are attacks at our identity, attacks at our sovereignty. And of course, the governing party in Poland will be able to show that Poland is deprived of the money it deserves. So it will again use the same tool. It is not about the legal aspect, but about the emotional aspect, about patriotism, sovereignty, and so on and so on. So what I mean is that the conditionality model will be effective if it is somehow supplemented with a narrative that is a well thought narrative, but why it is necessary. And this narrative must be directed to the people of Poland, not to the government. Because if this is simply a legal mechanistic tool and the European Union fails to convince the Polish people what is the axiological basis for this, why it is important, the law and justice government will do this for them. Yeah, of course, presenting the system as injustice, as depriving Poland of what it deserves, and so on and so on. So what I'm saying is that this is a good model of acting because of this abstract, concrete relationship, but it must be supplemented with a good narrative to oppose the bad narrative from the Law and Justice Party, from the Polish government.
Could I come back myself and ask a question there, which to you, Marcin, which might also then go into what you might want to say? What you're saying about a narrative, and that is a narrative which is obviously going into the field of politics. Is that a narrative that we can expect to hear from the court, or is it something which has to come from politicians? And if that is the case, if that comes from ones at the centre of the EU, is that going to be particularly persuasive in Poland, given what you say, or is there more that can be done by political leaders in Poland, as of course some do, to support that narrative?
You know, I believe, you know, everyone who takes care or believes that the rule of law is important should be involved in creating this narrative. There is a role for the courts, and I fully agree with Ian that, you know, it is difficult for the judges to communicate with the people in an understandable way because of tradition, because of, you know, the way the substantiation to the verdicts is written, and so on, so on. But judges have to overcome it. Yeah, they should be also aware about the anti-elitist syndrome, yes, which is present everywhere. And there is one simple rule here: if you speak in a complex language, the people who don't understand it perceive it as showing off. They perceive it as your instrument to show them that you are better than them. So using a simple language is a sign of respect to other people. So judges, of course, should be involved in it. They should change the narrative, but politicians as well. It is very difficult for the Polish opposition to talk about the EU intervention because, you know, they are presented to the general public as traitors. Yeah, yes. They are, and you know, this is an emotional language. It has nothing to do with intellect. So one needs to find a way of presenting this model, I don't know, as a new Marshall Plan, as something that you know, that connects to other ideas than simply the conflict between the Polish people and the EU. I don't have any simple answer, but the answer is everyone should be involved in it. And for me, as a Polish citizen, it is the most important thing that the EU can talk in the language of emotions and values, and not only in the technical language of law and procedures.
Thank you. Ian.
Yeah, I would distinguish between the two remedies or two mechanisms which are available to the European institutions faced with Polish obstruction. One is the imposition of penalty payments. Those are, although gigantic for individuals, relatively small in budgetary terms. We're talking only single millions, which of course mount up to tens of millions. The conditionality notion, for those who don't know it, is a concept whereby, not a concept, but a rule recorded in writing that approximately, if you don't adhere to our values, you can't participate in the benefits, notably the enormous economic benefits of receiving subsidies, support, investment contributions, big funds in the billions. And that's what's at stake at the moment. And I think it won't be difficult for the Court of Justice to find that the conditionality conditions have been triggered, and that therefore it would be justifiable to deny these sums, to huge sums, to Poland. Whether the folk in Brussels at the European Commission will have the fortitude to go through with it is a separate question. Second observation, is the EU using all the tools? I think no, not yet. But there is this constant balancing between the countries who are skeptical about European central power, the countries where there is a tension between the judiciary and the governing political party. That on the one side, and those towards the West who are completely convinced and completely converted to the notion of respect for European law and reluctant sometimes, but nonetheless necessary compliance with the judgments of the European Court. I very, very much agree with what Marcin has said about intelligibility. It is easy to make jokes, and we made them when on the court, about the difficulty of understanding the judgments of the court. If you look at the judgments in the 70s, the 80s, and some of them in the 90s, they're quite short. They're maybe 15 pages long, maybe 12 pages long, whereas, and they're clear. Whereas now they are 80, 90, 200 pages long, and the paragraphs cover all kinds of stuff. But the crucial paragraphs are only 3 or 4. But those crucial paragraphs may be inconsistent or may have to be balanced one against the other. I think that's a regrettable way of drafting. And it's therefore that I say that the Court of Justice can be bold with respect to the results, as to say, it will give a judgment which has powerful language in it, or it will uphold the decision of the council to deny this or that benefit. It'll uphold the imposition of a fine, but the judges of the court are not politicians. They may have been politicians, but the court sits there in Luxembourg to answer questions put before it. The enforcement, the respect, the promoters of the concept of the rule of law don't go as judges, even though the president of the Court of Justice, Koen Leenaerts, is an extraordinary expert, and his explanations of judgments of the court, normally delivered to university audiences, are spectacularly clear to lawyers, but to ordinary people, they don't normally attend his lectures.
Thank you, Ian. Now going back to the questions again. First of all, I see just had a question from someone asking you, Marcin, if you mentioned a poll linking EU interventions on rule of law issues to a rise of anti-EU sentiment in Poland, and the question asking if you could share the details of that poll, if you have that link handy, perhaps you could put it in the chat if you can find that easily. But while we're thinking about that, I want to turn to 2 questions which came in from Anthony somewhere, which I'm just trying to find, which was, to do with migration issues and as it's described, the granting of emergency powers to Poland and other Eastern European countries to deal with illegal migration. Does that show the EU is worried about the potential for right-wing governments to foster Euroscepticism and even lead campaigns to break up the union? So how far is the response to illegal migration at the borders leading to policies and suspension of legal norms because of fears of the consequences of doing otherwise? And a related question from the same person, perhaps an overlap, is isn't the economic downturns or invariably tends to precipitate change of governments if right-wing rather than centrist ruling parties? So is this really more to do with economic consequences for politics than anything to do with some of the more moral and philosophical issues? So I don't know, Ian and Marcia, those are both pretty complex questions. If you want to answer any of them.
Well, I would just observe that migration is a great way of pleasing a significant section of society, and saying that migrants have rights, that migrants deserve to be treated fairly, is a way of getting yourself condemned and ridiculed in the popular press, and that's very regrettable. So the use of migrants, immigration, and the social challenge that can present to a country, the use of that for base political purposes is really pretty dismaying.
Marcin, do you want to say anything on those questions?
Yes, first of all, as far as the poll I referred to is concerned, I will be happy to send a link, but I don't have it with me just now. So if I may ask the person who is interested to send me an email, it can be easily found on the internet, on my law firm or the university, and I will be more than happy to send it because I think it's worth analyzing. So please send me an email and I will respond with a proper link. As far as the migration crisis is concerned, so again, let me tell you a very concrete story. There is an NGO in Poland, a very conservative one and very supportive of the Law and Justice Party, who recently started a litigation about the journalist who took the photos of several small children from the migrants' families that were freezing in the forest near the border between Belarus and Poland. And I was wondering why a conservative NGO supporting the Law and Justice Party wants to start a litigation about the journalist because of a photograph. I think they realize how dangerous it is to them. You know, we can talk about the migration system, migration crisis at the very abstract levels, at the abstract of quotas and so on and so on. But when we see a picture, when we saw the picture of this poor Turkish boy in the red t-shirt lying dead on the beach, you know, that's such a powerful communication based on emotions. Therefore, the NGO, the conservative NGO, is so afraid that they start a litigation and they accuse the journalist that by taking the photo, they infringe the right to privacy of these freezing children. Yeah. So by using this example, I want you again to justify my thesis. We need a new narrative. We need a new communication because the migration crisis is used by the authoritarian governments to somehow strengthen the anti-diversity tendencies. Because if someone comes from outside, this person is different from us. So it's a gift for the Law and Justice government when there is a migration crisis. It requires a response again that not only touches upon the systemic procedural aspect of this crisis, but also the emotional aspect. Sorry for being so boring about this, but I really believe this is a crucial thing to understand, that we have to access this problem in a holistic way, and not only at the level of intellect and not only at the level of the system.
And to that answer, Marcin, perhaps is a good intro to the last question I've got on my Q&A question, which is from Jane, who I think must be in the USA from her question, saying that the need for understanding of explaining the rule of law is very obvious here in the US, and I'm sure that's true, we can say we're true of Poland, UK, and the other countries as well. Where is the public platform? So without necessarily going into specific models for particular countries, I mean, what are perhaps some more concrete ideas for how we can promote this awareness of the value, the need, and the wider context of a rule of law? Marcin, do you want to come back on that, perhaps, and then Ian?
Yeah, I can
that?
share with you some ideas that have been developed in Poland. For example, some very smart guys started what they call the constitutional tour. So they simply travel all around Poland with a huge bus, inviting some celebrities, some politicians, or some also lawyers. They have the text of the Constitution, the copies of the Constitution, the many copies of the Constitution. They visit small villages, then they visit small towns. They organize a discussion, an open discussion about the Constitution. They give to the people the copies of the Constitution. That's a hugely popular action in Poland, a very concrete one in which the Constitution and the people who defend the Constitution are very close to the individual, as I said. So they use this is a tool used in the political campaign, and the Constitution needs this kind of campaign. So that's one of the ideas. The other one is I work with some other people on a graphic novel that would explain the main ideas of the Constitution, the equality before the law, the proportionality rule, and other issues to children and to the young people by means of pictures, not only words. I think this is we have to be aware that we compete for the very short attention span of these people with a very attractive communication of the computer games, of the YouTube videos. We have to use this tool if we want to be effective in promoting the constitutional ideas. So this would be two, I think, concrete ideas that we try to develop in Poland.
Thank you. Ian?
I agree with everything you've said. I would just add this particularly to Jane, who seems to be in the United States. The Bill of Rights contained the first 10 amendments to the US Constitution, and there have been a bunch of others over the next 200 years. Now, the individual cases which shaped fundamental rights, the right to remain silent, the rules regarding abortion, the right to counsel, those cases are now quite old, but they are still valuable and intelligible in that they present the story that, if well told, they present a compelling story that is easy to understand. There's a book called Gideon's Trumpet, which describes the case of Gideon and Wainwright, where I think it was Fortis, not sure, an eminent US lawyer who did a lot of litigation before the Supreme Court, did the case of Gideon and Wainwright to the Supreme Court pro bono, and his client said, "Can I help?" And the lawyer said, "Well, Mr. Gideon, will you please write to me just the story of your life?" And the story, as told, was very compelling. Now, it's those tales, of which Europe has a few, but they're usually rather old because the basic principles on free movement are already pretty well established. Those stories can make a compelling narrative, and I think that they are underreported, underexploited, if that's the word, under-recounted today. So I'm all in favor of touring buses, webinars like this, and I absolutely agree with what Marcin has said. The challenge of presenting things badly or less brilliantly is well exemplified by the Brexit referendum. That was a catastrophe for good sense. Well, a catastrophe for good sense. I can see someone quoting that back at me. Let me say it was a regrettable historic error, more prudently. But it shows the potency of skilled communication in support of a misleading message. So I think I'm saying the same as Marcin. We've got to do a better job at selling what it is that we're committed to.
Okay, a question, thank you, Ian. A question I think probably, well, for both Marcin and Ian, in fact, a question as, what's your assessment of the possibility of Pole exit, or indeed any other EU member state leaving the EU as a result of not applying EU laws, values, or court rulings? Basically, are you likely to leave the EU because you're thrown out of the EU rather than they choose to leave? Perhaps Ian on that, and then Marcin?
Extremely unlikely. The candidates to be so treated receive so much assistance in the form of money that they would be most reluctant to be thrown out. And so, and I find it almost, but not quite, almost inconceivable that the member states would take the step of seeking to eject someone, a member state.
Marcin?
I can tell you that the Law and Justice government has already started a long-term plan of withdrawing Poland from the EU. It is not effective now because we are still a net beneficiary of being in the EU, but everything is being done to prepare the Polish citizens who generally support the EU membership. 82%, some polls showed 70% of Poles support the EU membership, but the situation will change and it will be easier for the anti-EU propaganda to convey their message if we become the net payer to the EU budget. So I'm really afraid, and I don't know the answer to this question. I think it is also likely that this long-term propaganda by the Law and Justice government will be more effective if the tools are used against Poland. Because if they are presented by the Law and Justice government as the attack at the Polish sovereignty, and there will be no answer or no explanation, no narrative we've been talking about previously to cover, to somehow protect this tool, it may well be the case that when the tools are imposed and used, it will help the Law and Justice government to go forward with their anti-EU propaganda. So there's no simple answer here. We need a reaction for sure, but it must be a wise reaction. And as I said, not limited to the procedural and legal aspect only, because it will be attacked by the Polish government with a lot of emotional propaganda that may, in the long term, decrease the support rate for the EU membership in Poland.
It is, one can observe that in the UK, a few months before the referendum, support for remaining in the EU was around 65%, and it dropped to 48% within a few months. And that is about government propaganda in favour of leaving the EU. So a warning and lesson to us all. It's now 6:30. We'll have to bring our event to a close tonight. I realise there are quite a few questions which were directed, but more about the Westminster UK politics. So that's after Joanna left. I thought it was better to concentrate on other issues for Ian and Marcin. This is certainly something which, for our party, European Movement in Scotland, hopefully European Movement more widely, will give a high priority in what we do, because as we heard so clearly from Marcin and from Ian, that the fight to preserve democracy, democratic values, the rule of law is all part of the wider effort to retain Europe and retain European cooperation. We go together, and it's emotional and political, and it has to be a holistic approach. And I think that was really valuable from our session this afternoon, this evening. I want to thank Marcin and Ian and Joanna in absence for taking part today. Thank you to all our participants for joining us this evening. I want to, in closing remarks, just to remind people that this event has been organised by the European Movement in Scotland. We're an organisation entirely run by volunteers. We have no big corporate or government funders. If you're in Scotland, agree with what we're doing, think about joining us or supporting us. In a second, you will get an email which gives you some links. It also, for those of you who are from outside Scotland, indeed outside the UK, links to the European Movement UK and also to the wider European Movement International Organisation. Our next event for European Movement in Scotland is one of a series of webinars with the various political party representatives in Scotland. We have of all the major parties. Our next one on February the 17th is with Sarah Boyack, who is from the Scottish Labour Party, who is the Shadow Secretary for European and Constitutional Affairs from the Labour Party, and we will have all other speakers during the course of the next few months. So once again, thank you all for joining us tonight. Thank you to our speakers. In a second, I hope that a slide will come up shortly, giving the email and website address for the European Movement in Scotland. And I wish you all the best on this Burns night as well. Thank you very much indeed.
Thank you.
Thank you.